All right. Okay. With now the introduction.
Sorry, Atul.
Yeah, I'm Atul Alexander. I'm a faculty in the West Bengal National University of Juridical Sciences from India. I teach public international law and human rights law for LLB and LLM respectively. Thank you.
Excellent. So Yael and Atul are going to talk to us about human rights obligations in the context of belligerent occupation. I read Atul's paper and I read a paper of Yael, who is relevant, I think, to her presentation, but I'm not going to say anything. I will give the floor first to Yael. No? Okay, the problem here is different.
Yeah.
I'll give the floor to Atul. Sorry, and then we'll continue with Yael.
Yeah.
Maybe you first.
Whatever, up to you.
Doesn't matter. Atul, are you ready? Would you like to go first?
Yeah, I'll then start. Firstly, I would like to thank the organizers for providing me this opportunity to present virtually, because for health reasons I couldn't be in person in Prague. But so I would like to thank the organizers for making this arrangement. So the paper that I would be presenting is on the functional approach to occupation and human rights obligations, specifically with regard to the recent advisory opinion of the World Court. Although in the paper I have not specifically dealt with the advisory opinion because it's a working paper. So the draft which I had submitted, I mean, it's a work in progress. So it was done in a very short period. So I would like to get opinions from everyone so that I could enhance this working paper. So coming to the template of my presentation, I would be giving a broad introduction on the topic first. Second, I would be discussing about the human rights obligations in occupied territories. Thirdly, I will be specific in terms of occupied Palestinian territories. Fourthly, I will be discussing about the functional approach to occupation, which would be the core theme of my paper. The next part would be discussing the overlapping obligations, that is the functional approach in international human rights law and how it overlaps with the functional occupation. Then I will try to identify an approach which is the novelty in the paper, which is the doctrine of proportionality, and finally I would end with a conclusion. Now going into the first part of the paper, where I talk about the law of occupation in general, which is unique to jus in bellum, which equally applies to belligerent participating in the conflict. And law of occupation is something that is codified under the Geneva Conventions, Hague Convention, and it is something that the UNSC has also endorsed. So essentially, occupation is something that is not outlawed, but in international law, occupation is actually regulated. And the Hague regulation sets out the detailed guidelines as to what the occupier, the rights and duties of the occupying power. Now going to the second part. What has happened is specifically there are a few cases in terms of occupation which the ICJ has specifically dealt with. Or before going into that, I've taken the case study of Israel-Palestine because this is a classic case of what we call as prolonged occupation in international law, and there is no sufficient state practice with regard to other states in the context of occupation. So it necessitated me to work on this specific issue. Now, when I have actually divided the paper into two parts. Firstly, I would have argued on the extraterritorial application of human rights in general, and this which would also include the application of human rights extraterritorially in occupied territories, which includes occupied Palestinian territory. Now, in doing so, what I have done is I have shown that firstly, human rights law applies in occupied territories. That is something that I have proven. Secondly, in the second part of the paper, what I have done is I have tried to integrate the functional approach which the World Court has identified in the recent advisory opinion to the human rights obligations which is applied extraterritorially, which I have discussed in the first part. So coming to the first part of the paper, the first case which I have discussed is the legality to the threat or use of nuclear weapons, where the World Court made it apparent and clear that human rights would apply in case of what we call as extraterritorially, except for Article 4 of ICCPR specifically. But the World Code did not go into the fact that it applies to occupied territories, and this was actually identified by the World Code in the subsequent case of the Wall Opinion and the armed activities case. So today, what is apparent through the decisions of the World Code is that human rights law actually applies extraterritorially. But the problem is, it is unclear as to what is the extent and scope of this application. Whether the entire corpus of human rights would be applicable extraterritorially, like for instance, whether social and economic rights would apply extraterritorially, or whether it is confined to definite set of human rights. So this is something that the World Code has not identified or made it very clear. This is one side of the development. On the other side, you have the law of occupation, and Israel's contention is actually it has disengaged from Gaza in 2005. But some scholars are of the view that still Israel is continuing to exercise what we call as effective control in terms of controlling the borders, ports, etc. So it is still an occupying power. And this is where the concept of functional occupation comes in. I think this was propounded initially by a professor by the name Ela Gross, and ICRC endorsed it subsequently in one of the reports, wherein it says the occupying power has an obligation vis-a-vis the occupying territory to the extent of what we call as effective control. So this means either it disputes or it reverts the fact that you either you are an occupying territory, occupying state, or you are not. It takes away the binary approach from the laws of occupation and sees occupation very objectively, in the sense if the occupying power is able to control certain portions or certain stretch of territories, and the rights and duties would accrue accordingly. Now, this is quite interesting because there is an overlap in the sense, on the one hand, you have human rights being applied extraterritorially. On the other hand, you have a situation where the World Code has said, World Code has said that occupation is essentially functional. I mean, the World Code has said this in the recent case, although the World Code has not clearly articulated this functional approach in the earlier cases, in the recent advisory opinion involving Israel and Palestine, right? So there I see a kind of overlap wherein I try to engage with this overlap in my research work, and these developments are actually very interesting because as Professor Theodore Meron would put it, today what we are seeing is a kind of humanization of international law, and this is something that is felt in the realm of international human rights law. And this is so apparent today because when we talk about functional approach, we are also essentially, talking about the entire debate as to the extraterritorial application of human rights, starting from the spatial approach. Then you have what we call as the personal approach to jurisdiction. Now the functional approach. So functional approach actually offers a kind of alternate to the earlier approaches that were propounded by scholars, which had a very broad application, right? Which had very broad application. But functional approach, in a sense, is very narrow because it talks about the obligation of the occupying power to the extent of its control over the territory, right? Now, coming to the next point, which I would like to highlight, which I have pointed out in the paper, is specifically on the overlapping obligations, which I've tried to again highlight in the paper. The overlapping obligation is with regard to the Am I audible?
Yeah.
So, am I audible?
Yes.
Yeah. So as I was saying, there is an overlap. On the one hand, you have international human rights law, which today is very evident and clear that it applies extraterritorially. And the problem is what the scope of the extraterritorial obligation is unclear. Second, you have a situation of humanitarian law, wherein there is a change, wherein it is said that humanitarian law applies functionally. So essentially, there's a kind of overlap between international human rights law and humanitarian law when it comes to the when it comes to the law of occupation. Now, what I'm trying to highlight in the paper is I've highlighted the extent and scope of this application. How far does human rights apply in case of occupied territory? Does the entire corpus of human rights apply in occupied territories, like you have economic, social, cultural rights, or whether it is confined to a specific set of human rights, which is resultant of the effective control that the occupying power exercises? Now, if you look into the previous scholarship on that particular topic, there were writings which alluded to the fact that which makes a distinction between positive obligation and negative obligation. This essentially means that if a state is having effective control extraterritorially, then to the extent of that effective control, the state is having an obligation which is negative obligation under human rights. But for all other purposes, wherein a state is not exercising effective control over those territories, for all those purposes, it's actually opposite. It's positive obligation. So the scholars have tried to make this distinction between negative obligation and positive obligation when it comes to the application of human rights extraterritorially. In a sense, it tries to limit the scope of human rights. Right? If a state enjoys or controls or enjoys effective control, then negative obligation would inevitably apply. But if not, obviously positive obligations would apply. If not, states are bound by what we call as negative obligation. So it would be interesting to note that if Israel is not fully controlling the Palestinian territory, or if it has disengaged from Gaza, but if it is controlling certain pockets of territories in terms of allowing entry and all, then Israel actually would not be bound by all the human rights obligations. It would be bound by certain set of human rights obligation, which could be let's say negative obligations under human rights. The other point to remember is that functional approach to occupation also endorses this particular view, right? Now, coming to the next point, although we make an argument that functional approach, or rather the distinction between negative and positive obligation would be sufficient to resolve this notion of extraterritorial application of human rights, this might not be entirely clear, because today we have an overlapping of what we call as positive and negative obligation, right? So there is an interdependency of right. So one cannot make a distinction between positive and negative obligation today, because there is an overlapping of rights. Secondly, it is not entirely clear how human rights law would be applied in case of what we call as extraterritorial, especially in occupied territories, in case of coming to the picture of non-state actors. Today, non-state actors hold a very important place in international law, and applying the conventional theory of jurisdiction extraterritorially, it becomes very blurred when it comes to the application of human rights extraterritorially, right? And this is where functional approach comes in, wherein it tries to apportion or segregate the responsibility between what we call as it could be state actor as well as non-state actor. By applying the functional approach, it becomes very clear that, let's say, if an organization like PLO or Hamas is operating in the occupied Palestinian territory, they also have certain set of obligations by virtue of this doctrine of functional occupation. So that would mean that Israel would not be entirely responsible for the whatever human rights violations or human rights obligations that it has. So because the responsibility itself would be apportioned in terms of what we call as effective control. So the obligation would be only to the extent of the control that Israel is exercising over the territory that is occupied Palestinian territory. Right. So with this, I think I'll conclude. I would like to get the opinions of, scholars on my presentation. Maybe I could improve on this.
Thank you, Atul. We'll move on to Yael's presentation, and then we'll collect the questions at the end.
Okay, so thank you, everybody. Timing. Yeah. I'm just putting it. Doesn't mean I'm actually going to get something to the answer. Despite the fact that this is a very friendly forum, or perhaps because of the fact that this is a friendly forum, I do feel the need to say that while we're having good Czech food and great company, there's still over 100 people who are being held hostage. Over 1,500 people were murdered on October 7th. There's 45,000 people killed in the course of the war, hundreds of thousands maimed and injured, hundreds of thousands, in fact, we're talking 2 million people displaced in Israel, Gaza, and Lebanon. And what we're doing is not unrelated, but we were having a conversation over breakfast about whether we were changing anything in the world. So, yeah. So in the context of not changing anything, but talking about it, I'm going to speak about occupation and self-determination challenges in application. And let me start with a preliminary point. The workshop is about human rights law and IHRL and contradicting obligations. And, okay. And to start with, I'm not going to be applying the human rights IHL paradigm for the analysis, because there's limitations in using human rights law when we talk about self-determination. I want to make a couple of points. I'll skip that. A couple of points on that. Usually when we speak about human rights versus IHL, we speak about individual rights versus individual rights. Self-determination is not an individual human right. It just simply doesn't work in the same way. The human rights analysis doesn't work in the same way. One of the elements is, for example, the fact that under human rights instruments, the right to self-determination is presented as unqualified, which doesn't mean that it's actually unqualified. Also, unlike in hostilities, where we kind of know what the relationship is between human rights and IHL, like specialis and all that, when it comes to situations of occupation, there's no preset hierarchy. So what does it help that we identified that these are the two categories of law if it doesn't actually provide us with a way forward? And finally, and perhaps most fundamentally, the human rights paradigm assumes a single community. The legitimacy of limiting the rights of individuals is that they belong to the community that benefits from the goal that is pursued by the limitation. Or if they don't benefit immediately as part of the community, they have the chance of benefiting next time when somebody else's right is limited for their benefit. That's not how it works with self-determination. The rights of individuals within one community are limited for the benefit of a separate community. So given that, what I'm going to, the full plan is to speak first about the whole notion that self-determination applies in situations of occupation, and then speak about what self-determination as freedom from occupation means and what self-determination means in a situation of occupation. So let me start with the idea that self-determination applies also in situations of occupation. I'm not going to go into the history about how the law of occupation has its origin in the notion and principle of self-determination. I'm going to start with the point where we started talking in terms of rights and law. And I'm going back to 1941, the Atlantic Charter, in which the US and the UK presented their vision for the next world order and what their goals were. And one of the points was that they respect the right of all peoples to choose of all peoples to choose the form of government under which they will live. And they wish to see sovereign rights and self-government restored to those who have been forcibly deprived of them. And what they were speaking of was primarily peoples that were occupied by the Nazis. So they were talking about self-determination from occupation at that point. Having said that, moving to 1945, where self-determination already appears in the Charter, although it does not appear exactly as a right. But what the Charter actually did was fortify the notion that states have the protection of the right of states to exist, which by prohibiting the use of force, by implication, or maybe the implication is the use of force, the idea that the notion that states have a right to exist And the law of occupation is part of that system, that there's conquest is no longer an option. We're stuck with a situation of occupation, and self-determination appears also in that context. So we still have the idea that self-determination is about the protection of states. At the same time, we have Chapter 11, which speaks of non-self-governing territories. So the idea of self-determination is being expanded to non-state actors. And the context is not only the protection of states from use of force, but also the notion that peoples have a right to self-determination as in the sense of not being governed by others, what we refer to as colonialism. And I mean, not being governed by others is a whole lot of things, but and here we come to the self-determination from colonialism, which I'm actually not going to expand on too much because that's a bit that we are all familiar with. I do want to point out that in the 1960 and the 1970 declaration, the 1960 declaration on the rights of, I forget the full title of the right of people under colonial regimes or something, and the 1970 declarations on principles of friendly relations between countries. In those instruments, there's already a reference to the notion that self-determination is universal and it goes beyond colonialism. So there's the first statement about the subject about all peoples. Sorry, the second paragraph. All peoples have the right to self-determination by virtue of which they determine their political status, and we always cite this as self-determination colonialism, but I want to point out two things. One is the fact that it's about all peoples and not just people under colonial rule. And it was intentionally, the word all was put there for that purpose exactly. And also that they speak of the subjection of peoples to alien subjugation, domination, and exploitation. Now, what those terms actually mean was never fully explicated. They were never defined, of course. But by 1970, it's clear that they go beyond just colonialism. And if we look at the travaux préparatoires of the declaration of the 1974 Declaration on Aggression, or Definition of Aggression, which also deals with that, they don't explain what these terms mean, but when you look at who were they thinking of, so these are the cases. They were thinking of Southern Rhodesia under the Ian Smith regime. They were thinking of the South African Bantustan, the TBBC, the Transkei, Bophuthatswana, Venda, and Ciskei. They were speaking of Guinea-Bissau under Portuguese government, of Namibia under the South African administration, of the Palestinian territories. Now, what all these cases have in common is that self-determination didn't actually complete as planned. So Southern Rhodesia is a case where decolonization from Britain to an independent state did not take place because the local white population basically took over and instated an apartheid regime. The South African Bantustans, I assume everybody's familiar with. South Africa basically did the same thing, except that it allocated territories that it declared to be independent states. Guinea-Bissau is a situation where Portugal basically rejected its status as a colonial power, and its status in Guinea-Bissau was declared an illegal occupation at some point by the General Assembly. Namibia is a situation where South Africa had a mandate. It administered it in violation of the terms of what was perceived as the terms of the mandate, including by an apartheid regime. The mandate was terminated. South Africa refused to withdraw, and I don't need to tell you the story about the Palestinian territories. What the last three have in common is the fact that in all of them, the administering states were regarded as occupants. So putting together the exploitation, domination, whatever that we have in the resolution on self-determination, and these are the cases. So put two and two together, get whatever you get. That the wording that refers to occupation also appears now in the standard, it's like standard wording in the resolution that is adopted annually by the General Assembly, the universal realization of the right of peoples to self-determination. And every year, the General Assembly welcomes the progressive exercise of the right to self-determination by peoples under colonial, foreign, or alien occupation, et cetera, et cetera. Again, what alien occupation or foreign occupation are has never been defined. So bottom line so far is that the link between self-determination and occupation has been there from the start. It was added to the entrenchment. Decolonization was actually added to the entrenchment of self-determination as a universal right for non-states. Now, when the occupied territory belongs to a state, we usually speak of it in terms of sovereignty and use of force and occupation. But when the territory is of a state that, or of an entity that had not yet become sovereign, then we hear terminology of self-determination. Now, how many territories do we have that have not yet become sovereign and have become occupied? They're far and few between. But the right to self-determination governs even then. So the question is, does self-determination operate in the context of occupation, like self-determination from occupation? Does it operate in the same way that it operates from decolonization? And I want to speak about two arguments that have been put forward about why the answer might be in the negative. So one argument was that the circumstances of occupation should or do inform the understanding of the right to self-determination. And the argument is that in the case of an occupation that has been established through conduct in self-defense over non-previously sovereign territory, the occupant's interest of sovereignty and territorial integrity may affect the breadth of the choice of the political status available to the territory under occupation. In other words, if we're talking about occupation through self-defense of non-sovereign territory, maybe self-determination would not be realized through sovereignty, but through something less than that. Now, I think you can guess in what context this argument was raised. And I'm not going to engage with all the various elements of it, just in whether it matters where the territory was occupied in self-defense, namely as a response to a military threat. Now, I would argue that the fact that this was self-defense is relevant, but it's not relevant to the political choice that would be available to the population, so much to the question of how do we get there. So military threat, the existence of a military threat, should impact how self-determination is realized and not the whether or if self-determination is realized. Because the state that is defending itself is entitled to defend itself, but it doesn't matter in this respect whether the threat comes from sovereign state or a non-sovereign state. For example, there's no suggestion that a state whose territory is an aggressive state whose territory is being occupied, its status should not be demoted to less than sovereign. So why would the fact of self-defense affect the status of the so-called aggressor, whether it's a state or a non-state? Now, given that we've got the advisory opinion now, one might ask, well, what does the advisory opinion say on this? Now, the advisory opinion, the recent 2024 one, says nothing about how the rights of whether Israel had a right to self-defense, acted in self-defense in 1967 or not. Now, you could argue that means that as far as the ICJ is concerned, self-defense is irrelevant to the argument about self-determination. I'm not sure you can make that argument because there's the treatment of the issue of self-defense is so scant and poor in the advisory opinion that I would not learn from it one way or the other. In practice, I think what basically, it's not that the court says whether there's a military threat or not is irrelevant to what we're saying, but rather the court doesn't consider that there is a military threat that needs to be engaged with. So we can't learn a whole lot from it if this is inapplicable on the facts. But the court does cite the Chagos Archipelago advisory opinion. So apparently, occupation, decolonization, same thing. So the other argument that I want to engage with is the idea that the right to self-determination informs the understanding of the occupation. And the argument here is that occupation, in certain situations, we shouldn't be looking at the situation as occupation because the population is actually pleased with the situation, or it's not hostile to the occupant. Or one might say, maybe this is actually not an occupation because this is not a hostile army as required for occupation under Article 42. This is an argument that has been put forward I have this list of cases, and I know South Ossetia or Tskhi region and Abkhazia occupied by Russia, Crimea occupied by Russia, Transnistria occupied by Russia. The only exception in this context was Nagorno-Karabakh, which was occupied in the sense by Armenia, no longer a particular case. But I think, speaking of it in terms of what does the population in the occupied territory wish for, is the army hostile to it or not, or is it helping it realize its right to self-determination, actually misframes the issue. Because the question is, who is the population whose will we need to be looking at, and who do we measure the hostility against? And it's not the population in the territory, it's the state from whom the territory had been occupied. And if the population in that territory did not constitute a self-determination unit before the occupation, it doesn't become a self-determination unit by virtue of the occupation. So as long as there's hostility between the occupant, between the state in effective control of the territory and the state from whom the territory had been occupied, then we have hostility and we have an occupation. To be fair, the claim that occupation actually furthers self-determination usually follows. It comes in situations where there was already an earlier demand for remedial secession. So the occupation is just a technical thing. The claim is we were a self-determination unit. The occupation just followed it. But the argument on remedial secession is not a very strong one. It's not been accepted. So if you put remedial secession plus occupation together, the claim doesn't become much stronger. It's relying on a broken reed by adding another broken reed. You just have two broken reeds. It doesn't hold very well. So bottom line of when we speak about self-determination as freedom from occupation, self-determination does not negate occupation, nor does the right to occupy shape the right to self-determination. So the right to self-determination from occupation does not seem to differ from the general right to self-determination, if we can call it that, in the context of decolonization. Now, this leaves the question of whether self-determination under occupation, what that means. And this is not something we can draw on from the law on decolonization, because in the law of decolonization, there's no such thing as self-determination under colonization. It's just colonialism needs to end. And it needs to cease immediately and unconditionally. But occupation, unlike colonialism, is not absolutely prohibited. So the question of how the two, self-determination and occupation, apply side by side does arise. So self-determination means that the occupation must be administered in a manner that does not undermine the potential for realizing the right, namely sovereignty or whatever it is that the people choose. And this is familiar as the rationale for the law of occupation. But what does speaking about self-determination actually add? So going back to the advisory opinion, here are the key statements from when the court said, well, this is what self-determination, the components of self-determination in the situation of occupation. So first, the court recalls that the right to territorial integrity is recognized under customary law as a corollary of the right to self-determination. Second, by virtue of the right to self-determination, a people is protected against acts aimed at dispersing the population and undermining the integrity as a people. A third element is the right to exercise permanent sovereignty over natural resources. And fourth, it's the right to determine political status and pursue economic, social, and cultural development. So what do we have here that most of these things are actually already covered by the law of occupation. So I'll start with the second element. The integrity of the people is actually covered by Article 49 of the Geneva Convention about the prohibition on deportation and introducing the civilian population of the occupant into the occupied territory. Permanent sovereignty over natural resources is covered by Article 55 of the Hague Regulation, which is more and more commonly interpreted in light of the right to self-determination. And the idea of internal development is actually covered by the principle of Article 43, which says change nothing in the territory unless absolutely required, unless necessary. And in fact, the only thing that we're sort of remain with that is added by the right to self-determination is the idea of territorial integrity, but that is actually in the underlying principles of the law of occupation of the jus ad bellum, the idea that you cannot acquire territory through use of force, and therefore the territorial integrity of the occupied territory remains intact. So the question is, what does speaking about self-determination in a situation of occupation give us that we didn't have already? And I think the answer lies in the fact that the law of occupation, the prohibitions and obligations are articulated with respect to the individual. And by adding self-determination, we're adding the collective element to it. And this does speak to many debates over how the law of occupation should be interpreted. And the final question on this issue is, how do we move from an impediment to the right to self-determination to a violation of the right to self-determination? Because I think it's in the advisory opinion of 2004 that one of the judges, I think Judge Gorman, said something like, occupation is by definition a restriction on self-determination. We know that, but not every restriction is a violation. So how do we make this transfer? And in the current advisory opinion, the court speaks of lots of impediments and then says, well, there's a violation. And the question is, how did it make that transition? So one option is perhaps all these components are actually absolute. So the right to self-determination is not absolute in general, but territorial integrity is an absolute right, or demographic integrity, etc. Another possibility is that, in fact, all the impediments that the court cited was conduct that was in itself a violation of IHL or human rights law. So perhaps if a measure is a violation of these laws, then it cannot be a legitimate limitation on the right to self-determination. The problem is that if we accept this, then basically self-determination and IHL become conflated, or human rights law, they become conflated, and there's no difference between the various regimes. I think what is key in the advisory opinion is the fact that the court speaks of the prolongation of the various violations in a way that jeopardizes the right to self-determination. And here there's an element because there's a judgment call, because a violation of human rights law and IHL in the law of occupation it's an issue of conduct. We're not looking at what the goals are or what the prognosis is. But in the case of self-determination, we're looking at the political implications. So what we're saying is there is already a violation of human rights law or IHL, but we see where this is going. And this is what makes it a violation of the right to self-determination, in this case, based on the fact that it's been going on for so long, and it doesn't seem to be yet. What the court says with respect to the OPT is it's been going on for a long time. It doesn't seem to be going anywhere. We can see where this is going. To wrap it all up, there's actually no novelty in applying. Wow.
Let's stop here.
There's no novelty in applying the right to self-determination to situations of occupation over non-self-governing territories. That's the interesting bit. So far, the right to self-determination under occupation does not seem to generate new obligations or prohibitions, but rather calls for the consideration of the collective aspect of the violations and their political implications. Thank you. Yes, and if you want to reach me, I'm available on all these platforms.
You also can Twitter? You're on Elite Twitter? Yeah.
And Bluesky.
Bluesky.
Fine. Thank you very much, both Atul and Yael. I have some questions, but because we have experts on the Israeli-Palestinian issue and we have experts on extraterritorial human rights, I'll open the floor for questions. And if you don't have any questions, I can start. Are there any questions, comments, reactions? Solon, yes, please. And see.
Yes, first of all, thanks to both speakers, Yael and Atul. I have one question for each. And I assume now that I don't have.
So just to make sure that Atul.
Yeah, this is what my remark now is.
So the question.
Excellent. And how loud does it speak? Maybe you can capture my voice.
Atul, can you hear us? Are you still with us? You're muted.
I'm audible? I'm audible?
Yes, we cannot
Yeah,
see,
well,
but yeah, we can hear you loud and clear. So that's the first question. Yes.
So Atul, also welcome from my part. And my question is about functional duties. By the way, I haven't taken advance that I adhere to your stance. I agree with you. So my question is going to be kind of supportive, elaborating question. We have so far, you mentioned also the case of Israel and Gaza, and then you posted how in essence we can have functional rights, the allocation of rights and duties. What is happening though? So far, the Gaza president relied on the fact that Israel was outside Gaza, and then in Gaza we had Hamas. Israel was controlling all the passages maybe to the strip. What's happening now with the new reality that the Israeli army will stay in Gaza, meaning in a situation where you have pockets of Israeli presence inside the strip. And then you won't maybe have Israeli authority presence in other segments of Gaza. There, the assumption, according to the functional approach, is that maybe Israel will be responsible for what's happening in the segments that is controlling, and not responsible for the segment that Hamas is controlling. But then, because the strip is a small, and in essence, maybe we are going to reach a situation where two enemies, Israel and Hamas, will have to cooperate. And my question is, what's happening there with the functional approach? Maybe the functional approach doesn't work where the two enemies have to coexist, especially in a small piece of territory. This is my question about the functional approach. And to Yael, thanks again for the presentation. My question is, again, I very much enjoyed the whole ideas. What's happening based also on Morocco and Western Sahara? Can we say, because usually when we speak about the result of self-determination, we associate self-determination with independence, and especially under the colonialist regimes. Now, since we're speaking about occupation, and again based on the Moroccan precedent, just to put it on the table for people who may not be aware, we have now the tendency, although Polisario fought for years for independence, the last tendency, also sanctioned by the France and by the United States, is for autonomy to be given to Western Sahara. So my question is, Yael, since you made, I think correctly, the disengagement of the self-determination from colonialism also to other cases, can we say that in these other cases, maybe the lasting result would not be necessarily independence, but maybe other forms of self-determination like autonomy? Thanks.
Okay, I think we should give an opportunity to the speakers to respond. Atul, would you like to go first?
Yeah, I hope I'm audible.
Yes.
Yeah, one of the challenges with the functional approach is to demarcate or apportion the responsibility, especially when it comes to you have elements of non-state actors in Hamas, which is also exercising effective control over certain pockets of occupied Palestinian territory. That is one issue. But the thing is, the better alternative to the binary approach would be the functional approach, considering the fact that, for instance, on the one side, scholars from Third World argue that Israel is a prolonged occupying OPT. It's a kind of prolonged occupation. Now, that would mean that it cannot use certain things, like it cannot use force, or it cannot intervene in the internal affairs. Like you have a group called Fatah and Hamas carrying out. There was violence in early 2000s. Now, if you say Palestinian, Israel is not an occupying territory, it cannot actually intervene. Otherwise, it can. So, what I'm trying to highlight is a better approach in comparison to the binary approach would be the functional approach, where you are fixing responsibility to the extent of which the occupying power exercises control. Now, if one goes by the other approach, that is, if one assumes that Israel is the occupying power, and you say human rights applies extraterritorially, then Israel would be bound by all the human rights obligations, right? Which might not be anywhere related to, Israel's presence. So, if on the other hand, if one says Israel is not an occupying power, then the problem is IHL entirely doesn't apply. The provisions of Article 43 ceases to apply. So again, which would ensure that innocent civilians are killed by acts of non-state actors. So a better approach in comparison to the existing approach, that is the binary approach, would be the functional approach, right? Thank you.
Okay, so Morocco and Western Sahara is really interesting. And when I showed which are the cases that the instruments refer to, I would actually put Western Sahara there as well, except that it only became occupied in 75. I think the instruments were before that, so they didn't know it, but it had been applied later. I think what you're referring to, there's the international community is well, I don't know if the U.S. and France are the international community, but they're definitely leaders. They are moving away from, are moving towards giving Western Sahara, making the realization of self-determination of Western Sahara the options of either autonomy under Morocco or autonomy under Morocco. But I think that's a political issue rather than a legal one. So legally, this is it's not the self-determination. It's changing its shape at this point so much as there's not sufficient insistence on applying the law of self-determination in a situation of occupation. But I think it starts from the fact that Morocco has managed to turn the debate away from the terminology of occupation altogether a long time ago. But I think that the question is, well, maybe the Western Sahara model is self-determination, in which case, why not apply it to in the West Bank or occupied territories? This is an argument that is made by proponents of the current Israeli government's policy. You could equally make the opposite argument. Well, why should the situation in Western Sahara not be dealt with in the same terms that the occupied territories, the Israeli occupied territories, are being dealt with? So, what is the standard that the other case should adjust itself to? The argument is symmetrical. I don't think that legally it's symmetrical. Because the debate relating to the occupied territories is carried out in line with international law in this respect, and not the Moroccan and what is happening in Western Sahara is not aligned with international law. But yeah, let's see who gets there first.
I think see.
Yes. So one comment regarding the functional approach and a comment and a half regarding the self-determination. Regarding the functional approach, I think that on the practical level, the problem with the functional approach is the tendency not to attribute sufficient responsibility to the non-state actor. So actually, when you adopt a functional approach, it's a way to put additional duties, sometimes unrealistic duties, on the state side, and not to place sufficient responsibility on the non-state actor. So if I think, for example, on the Gaza example, and I think on the pre-7th of October, so the assumption that there was an element of occupation there, put aside the fact that it ignores the notion of siege, it ignores the fact that it took the IDF a month to gather up sufficient force in order to enter Gaza. And it required it to double the amount of combatants. So 250,000 reserve soldiers were recruited, and added 250,000, if I remember the numbers correctly, of non-reserve soldiers, of regular soldiers, and that is only when they enter. And that is simply ignored when under the assumption that Gaza was already occupied. Same, by the way, in the discussion regarding Jabalia. In a really small area, you have 3,000 Hamas fighters and intensive fighting. To assume that that area is already occupied places obligations on the IDF side that in my perspective are first unrealistic and also diminish the responsibility of the other side to the conflict.
Just a clarification. Do you refer to the functional approaches or like to occupation in general? Because you can say that you have that since you need to use a lot of force to conquer the territory, then everything that comes from actually controlling the territory, including all of the obligations of the occupying force, is not there yet.
My argument that there's no effective control.
So it's not even a matter of functional approach.
Yeah,
we're not even in the.
I'm saying that once you look at it as a functional approach, you are skipping that step of asking actually if there's effective control and to begin with. And now
but that's the whole point. The point is that control is not the yes or no, but is a sliding scale, and that the more control you have, the more you're not skipping the step.
I'm aware that that's the point of the functional approach. My point is that point misses two issues. It misses a realistic, it places an unrealistic requirement many times on the state party. And this is what I meant in this is the point I try to make in these two examples. And it ignores the fact that there is a non-state party that should be held more responsible and duties and should be required to fulfill much higher duties compared to the extent that it is bound under the way that the functional approach is actually realized.
But can I, before you just comment on when you said, usually when we say, in the context of Gaza, Israel is not controlling, but what is it? Its ability to, it doesn't have boots on the ground, but it's the potential of taking control over territory quickly. And you're saying, look, it took it a month.
There's no potential of taking it quickly.
But I'm just thinking, usually we think of it in terms of, what is the military ability to control the territory? What took Israel a month was not so much military ability, but internal issues. And I'm just wondering, do we count that? Do we include that in the calculus? When the military
but I don't think that's
there.
I don't think that was the issue. I think that the issue was to realize that there are 700 kilometers of tunnels underneath Gaza and to think of how to conquer it. Because there was 40,000 fighters and 700 kilometers of tunnels, I think that the temptation was to enter immediately. Just on
I'll abuse my position as chair. I'll add a different dimension to what you're saying, because I was listening to his presentation and I read his paper, and I mean, he rightly points out that there's a difference between Gaza and other occupied territories, because what we're discussing now, because there were no Israeli forces on the ground. Okay, but I was wondering about effective control, functional approach. Nobody goes in Gaza or leaves Gaza without actually being vetted and get permission from Israel.
So that's siege. That is siege. That is not occupation.
Yes. Okay, I'm not talking about occupation. I'm trying to figure out about how human rights law comes in the sense that, for example, you don't allow scholars to enter Gaza. Isn't that a violation of the right to education? You don't let medicine go into Gaza. Isn't that a violation of the right of health? You don't let food go into Gaza. I'm not talking about occupation or the situation now.
But human rights are different from IHL.
Yeah, so I'm trying to understand what's the meaning of it. Would we talk about effective control in that sense? We wouldn't talk about effective control.
Well, some human rights jurisprudence, as Atul was saying, has focused, for example, in the Northern Cyprus cases on that idea of control. And the functional approach, so there's a functional approach in the IHL occupation context, and then there's a functional approach in the human rights context, and they're not necessarily the same, right? They have the same basic idea that that rights are on a sliding scale, but they don't necessarily work in the same way, right? So your argument, the argument sort of that you just teased out could be that even if IHL law of occupation doesn't apply, human rights law might apply. So you might say in response to Ziv, for example, that maybe Israel is not the occupying power in IHL terms, but it controls the ability of the Palestinian population to exercise the right to food, yeah? And therefore it has all sorts of obligations under the right to food or the right to health or the right to water. You see what I mean? Yeah. Which are not necessarily IHL derived. Yeah. So a problem, and so a sort of comment I have on Atul's presentation is that if you look at recent jurisprudence of human rights bodies, there is one particularly bad judgment or unfortunate judgment, which is a judgment of the European Court of Human Rights in the, no, not that one. But even though that's horrible too. So we shall see what they do with all the armed conflict stuff in the forthcoming Ukraine-Russia judgment, which will come soon. You know, that's going to be the big armed conflict. But the bad one, I thought, or at least from people who are of Atul's sort of general disposition, right? A bad one from their perspective that I think, Atul, you need to grapple with is this Duarte Agostino judgment, which is about climate change. So you'll remember there was this set of climate change decisions this year. The big one is called Clima Signorina, and it's about this duty to mitigate climate change under human rights law. But one case was litigated, this Duarte Agostino case, arguing that there was an extraterritorial duty to mitigate. So that basically Portugal had the duty to mitigate climate change, not just with regard to people in Portugal, but with regard to people all over the world. Yeah? And the court said no. And even though the argument was made expressly in terms of the functional model of extraterritoriality, the court rejected that model. Didn't just say, you know, we don't like it in climate change. It expressly said we don't like it at all. And that's a really bad thing for various other contexts, from cyber stuff and surveillance to war kind of scenarios. And that's kind of like, that court has again adopted a very rigid position. So that kind of sucks, like if you're a proponent of the functional approach more generally.
Before you go to
Yael, I'm not necessarily against it. I just think most of the time, well,
you're not necessarily against it.
I'm not necessarily against it. So when the functional approach, so negative duties will apply all the time anyway. So the question is always going to be, when do positive duties apply? And that's always the critical issue. Like, what does Israel have with regard to Gaza and to right to food? So.
Right. Atul, we discussed a lot. I don't know if you want to respond or have any reflections on what we have just mentioned about the functional approach and extraterritorial application of human rights.
Yeah, I have a few observations to make. This is with regard to this. I have a few observations to make. This is with regard to what Professor Marco had pointed out. With regard to the foreseeability. Now, in climate change, a state cannot be held responsible under the current existing human rights law for the human rights violations unless there is a nexus that is established. So when it comes to functional occupation, it becomes very difficult to establish that nexus. An analogy can be drawn to the climate change. And the second point I would like to stress, which I have not made in the presentation, is the contradictory view taken by the Supreme Court of, if I'm right, the Israel and the government of Israel. Now, government of Israel is pretty much clear that we are not an occupying territory. IHL doesn't bind us. Right. Therefore, we are not bound by any kind of human rights obligations. But if you look into some of the decisions of the Supreme Court or the HCJ of Israel, they have made it very clear that there is a possibility that human rights could apply extraterritorially. But the language of these decisions are more in line with IHL, although there seems to be an overlap with human rights. So, for instance, the courts in Israel have made reference to, if I'm right, freedom of speech and expression in occupied territory, but using the language of Israel's basic law and also the language of IHL instead of going into discussing the provisions of human rights law. So there seems to be a contradiction wherein the government takes one side and Supreme Israel courts in Israel have tended, especially if I remember, there was a judge who made it very clear that when it comes to detention in the occupied territory, human rights law should be applicable. So there seems to be a contradictory position. On the one hand, you have the government which saying IHL human rights doesn't apply. The courts in Israel saying that it applies to a limited extent, in a sense, adopting a functional approach. So there is a kind of dichotomy. So that is also a reason why functional approach could be applied, because there's no clarity with regard to the position of Israel. What courts has taken one approach, the government has taken another approach, right? So functional approach could augur well there, right? Thank you.
Thank you, Atul. See.
So 2 comments regarding your presentation here. One, I think that a case in which it can be argued that the claim that lack of austerity between the occupying power and the local population, a case in which this argument somewhat worked, is the case of Goa. Because India, formerly it's an occupation by India, or at least used to be an occupation by India, and that argument was relatively successful. Nobody treats Goa today as an occupied territory. And another thing, in general comments, I think that the added value of adding the argument of self-determination is that it places much stronger normative weight or pressure to end the occupation. Because within occupation law, the norms that pressure the occupying power to stop occupation are rather weak, if not almost non-existent. And self-determination gives that additional normative weight to aspire to end the occupation.
Right on both. I think in the case of Goa, it's another example in the sense of like Western Sahara, where the legal implications of the situation are not necessarily followed properly to the end. And I acknowledge that if again and again the law is not applied, but something else happens, then maybe the law is actually not what we thought the law was, and it's changing. Fair enough. I think these cases are still far and few between. And everything is overshadowed by the very legalistic discussion of the Israeli-Palestinian conflict, or at least according to some, it's all about law. With regard to the added value of self-determination as the obligation to bring the occupation to an end, I think if an occupation is managed in a way that does not in itself violate the right to self-determination, managed according to the law of occupation, where all is well, where basically, if to put things on the table, if the population of the occupant is not brought in with everything that comes with it, because this is what the story is in the advisory opinion. If that does not happen and other violations don't take place the way Morocco does in Western Sahara, exploitation of resources, etc., then the right to self-determination would not be an issue. It would be a permissible limitation. Sorry, the occupation would continue to be a permissible limitation on the right to self-determination until the conflict is resolved. There wouldn't be this pressure. Self-determination means that occupation cannot be perpetuated, but we don't need self-determination for that. So
here is why I disagree with you.
But basically what I'm saying, if there's no claim of violation of the right to self-determination, I'm not sure it's going to help that much, but I'm not saying...
So here is why I disagree. Let's imagine a perfect occupier, but that is dealing with a strong opposing non-state actor within the occupying territory.
So there's hostilities going on?
There is hostilities, but there is effective control.
Yeah.
But that occupier needs to take significant security measures that are permitted by the law of occupation, but harm the rights of the local population. I think that in that situation, the issue of self-determination would still carry weight of pressuring the occupiers to aspire to try to find a way to end the occupation. I don't think it's only in situations of violations.
Okay.
Your argument is basically there's some kind of necessity requirement, right? That, you know, at some point the occupation is no longer necessary to outweigh the self-determination concerns of the population.
No, that's a situation of a violation. If arguing, let's assume there's no violation of self-determination. I think the law of occupation already includes this element that it needs to be temporary.
Yeah, but there's never an end point.
Right.
And this is why self-determination simply adds a normative weight. It doesn't add a date, an exact date, but it adds this normative weight, a stronger normative pressure to end the occupation.
Okay. I'm not going to let the two of you continue because...
No, I agree with you.
Are there any other questions? You have a question?
So about the ICJ advisory opinion, you know, which is a really interesting decision in many respects. I mean, it's quite nice to observe. Like, so you have a 15-judge court, and they need to obtain as much consensus and as great as a majority as possible. And then that leads to a lot of silences and ambiguities, which are quite deliberate. It's not like they don't know what they're doing. I mean, it's quite deliberate how they craft the thing, right? So, for example, on the functional occupation thing, it's really interesting to see how they expressly adopt some variant of this idea that occupation is not binary. But a way of reading that is to say that even though Israel is not the occupying power now, it was the occupying power, and some residual obligations remain. So this is evidence of, for example, if you look at the Japanese judge, look at his separate opinion, he says expressly, we're adopting a functional approach to the law of occupation without ruling whether Gaza was occupied and at what time was it occupied. Kind of interesting, yeah. But then the thing that interests me the most is your self-determination stuff and interaction with occupation and self-defense in particular. So the court expressly says that the legality of occupation is an ad bellum issue, but then it doesn't mention the term self-defense at all. So if you do a search, the opinion doesn't appear at all. So it's not like it's can't, it doesn't exist.
It's a response to a military necessity. Occupation, which is a response to a military necessity, blah, 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 which is interesting because occupation is not a response to anything. Occupation just happens.
So they talk about Israel's security concerns, but they don't talk about self-defense. Partly that, though, to their defense, partly that's because if you look at how the case was argued, it was not argued in terms of self-defense. So if you look at Israel's submission, it doesn't say, and we are justified to be there because we're exercising our Article 51 right to self-defense. So you kind of can't blame them. But then in separate opinions, you have Judge Charles, who, for example, says, even if there was a right to self-defense, it's no longer necessary, it's no longer proportionate, right? Or you have, you know, the Judge Cleveland, Judge Nolte, who basically say it's tainted by an ulterior purpose. But basically, my question to you is, let's go to a simpler example. I mean, this Israel-Palestine thing is just a migraine thing, right? Let's do Ukraine in Kursk. Okay, so Ukraine is now the occupying power of a teeny tiny bit of Kursk. Yeah? You tell me, does that engage the right to self-determination at all? And whose right to self-determination? Is the people of Russia at all, you know, is their right to self-determination at all engaged by Ukraine's occupation or not? If Ukraine tomorrow said, we're annexing Kursk, does that interfere with anyone's right to self-determination or only with the norm of prohibiting the forcible annexation of territory?
It's not either or. I think it would interfere with the right to self-determination of the people of Russia. I'm not sure why you're specific. So
there's no Kurskites, you know what I mean? There's only the Russian people.
Yeah.
That's the only people who's relevant. So does the occupation of Kursk interfere? I'm going to eat my thing. Does it interfere with? Both at the same time? I'm going to stop. So
I'm going to make it mine so I don't have white stuff.
Exactly. Yeah. Does it interfere with any one people's right to self-determination?
The Russian people's, but I think that it's so much stronger to speak of the prohibition on the use of force and the prohibition on acquisition of territory by force than to speak of self-determination, which is, to be fair, wishy-washy. That I understand why discourse focuses on jus ad bellum issue in terms of jus ad bellum and acquisition of territory, rather than the self-determination of the people of Russia. I'm not sure, but I don't think that by speaking of the self-determination, okay, so you know how Antonio Cassis said, self-determination of the people as opposed to the right of sovereignty of the state. I think that those are the corollaries. It's easier to speak of Russian sovereignty and occupation and prohibition on the acquisition of force, which is an absolute prohibition, than to speak of the right to self-determination of the Russian people, which who knows what this means. It doesn't add anything. Which is
so in the case of the Golan, for example, do you have the same issue? So is there a people whose right to self-determination of Golanites, or is it just the Syrian people? And is their right to self-determination even involved by Israel's annexation of the Golan?
It is, but why go there? We can just speak about Syrian sovereignty and acquisition of force. Which is I think the reason why self-determination has been relegated, well, not relegated, but been left for issues when there's no sovereignty to speak of. So then we speak of self-determination.
So would the outcome, imagine the advisory proceedings concerned both the Golan and Palestinian territories. Would the outcome of the advisory opinion be different for the Golan, where the right to self-determination is not at play, than it is with regard to the Palestinian territories? Would the court say you have to leave the Golan as well, because you're forcibly annexing it?
But did we agree that it's not in play? Like in course, it seems to me, yeah. So there are the people, of course, and it depends on the time frame. And this is like, so if you assume, for example, let's assume that Gaza was occupied and the West Bank was an independent Palestinian state. Don't you think that the right to self-determination would be? No. No, it's my mom. She thinks that. So, don't you think that the right of self-determination of the Palestinians in Gaza is relevant even if there's an independent Palestinian territory?
Sorry, it's hard to take you seriously.
But
it's irrelevant to the issue of the phone, I think.
So this was the first. I do think that this is how it shapes. So maybe initially we don't think about the people in Kursk as something independent, but the occupation in a way creates this notion of the right of self-determination of those people who become occupied. I think this is how it is.
It's interesting because normally we regard the people as being the title holder of that right.
Yeah, but the question is, who is the people?
Exactly.
But we define the people by the territory.
So we know that in different cases, we have different interpretations of what's people, and I think that reality, in a way, shapes the way that we think about it. And if we assume that Kursk will be occupied for the next 20 years, we will. Depending. And so this was the first. I do think that you can have distinct communities, even if there's stated.
Give it 20 or 50 years, and the population of Gaza will be different from the population of the West Bank, but that will be because they will have that would be justified if. First, it will be justified on the grounds that they will have developed an understanding of themselves as distinct politically from the West Bank and probably vice versa. It's not just to be separate. It's not a geographic separation. Yes, although we don't really look at how people define themselves, because if we did, then Nigeria would have would be justified to divide Nigeria into 50 different states.
And the second was that your point about the functional approach, it just means that there's the only way that the functional approach makes sense is in cases of pre-existing occupation. Because, ask your students, right? So have all of this, you have the United States, they have a maritime siege of Cyprus, they control the airspace or whatever. Is it occupied? No one will think that it's occupied. I mean, we have in the history thousands of cases of this type of interventions or whatever that no one thought about it as an occupation. But it makes sense that if the territory was occupied and you have some kind of control, then you adopt a functional approach. And this is why it's not a coincidence that they talked about it in this sense, because it's to me, it's the only way that thinking about functional approach to occupation.
I disagree with you regarding. So if you trace back the origins of the functional approach, it didn't start with Pictet. There is a source that to this day I found is the 1914 UK Manual of Military Law. It has one footnote that says the law of occupation should be applied as far as possible, even in the field of battle. And I still haven't found the source from which they copied that idea. But that is the beginning. So the notion of this functional approach of partial or application of the law of occupation, even in non-occupation situation, is actually developed in situation in which it was. So the thought was that it's fuzzy. Because effective control is a fuzzy notion, you should have a gradual application starting from the field of battle. And where you see actual application of that is in the seminal case of the Israeli Supreme Court in the First Lebanon War. So the seminal case is always remembered regarding the discussion of occupation, but actually Shamgar says it's irrelevant if it was occupation or law or not, because even if it's not occupation, we have a duty to apply as far as possible the law of occupation even in the field of battle, and therefore the people that we detain already in that state acquire the rights that detainees in an occupation are eligible to. So you can apply a functional approach even in situations in which there's no previous occupation.
Something like that. Okay, I think I will have to stop you here. Sorry, it's time for a break. So I think we should thank Atul and Yael. And so I think it's time for a break.
Yep, time for a break.
What time are we resuming?
Assuming at 11:15, which means 11:20.
Okay.